Hi there, my name's Richard Joel Jr. I'm an attorney located at 496 Kinderkamack Road, Oradell, New Jersey. That's Bergen County, New Jersey. Today I'm going to provide a short overview of litigation, the civil litigation process. The civil litigation process means that there's a lawsuit that's filed by a certain party. Say that I'm representing a client and the facts and the law provide a certain basis for a claim. A complaint will be drafted, filed with the Superior Court. A filed copy of the complaint will come back. We will prepare a summons and then serve that complaint upon the defendant. The defendant will then have 35 days to respond to that complaint. They can either file an answer or a motion. After that party files an answer, let's say, then you will have the discovery process. There'll be a certain time frame wherein the parties can conduct discovery, and discovery can take many different forms. It can be either by interrogatories, document requests, demands for admissions, or depositions. Or there can be inspections of property or medical examinations, so it will depend upon the type of case and the type of claim that's involved. The discovery process will go on for a certain period of time, and then the parties during that time might file certain motions that pertain to the case, either trying to get judgment as a matter of law, or maybe they need certain relief from the court during the process, either to compel discovery or certain other issues that are involved. After the motions and the discovery are completed, the parties will receive certain notices. Certain cases will have mediation or arbitration through the courts. These are diversionary programs, complementary dispute resolution programs, where mediation is where a mediator will be provided, where the parties will present their case to the mediator. The mediator will try to facilitate working out a settlement between the parties. Sometimes it's successful, sometimes it's not. Arbitration is another mechanism that's provided by the courts in certain cases. This is where the arbitrator will hear the case and review evidence from both parties, may hear witnesses, and then make a decision what they feel should be the result in a certain case. Usually it'll be a non-binding arbitration unless the parties agree otherwise. If the parties do not agree with the arbitration result, they can object to it, file a trial de novo is usually the term that's used, and then the case will be put back on the trial calendar. So say that you got past these complementary dispute resolution programs, then you'll be slotted usually for a settlement conference where the parties will come in and conference the case with the court to see if a resolution can be obtained under the circumstances. A lot of the mechanisms in the court are geared towards resolving cases, because if you had to try every case that the court has received, we'd probably be trying cases from the 1800s. So the court tries to resolve cases, but not all cases can be resolved. Sometimes you'll have to go to trial in a certain manner. And even if a matter goes to trial, it doesn't mean that it goes to trial on all issues. You can resolve some issues in certain cases and then go to trial on the other issues to have the court decide. You can either have a jury trial or a judge decide the case. And when you go to trial, you'll have to do a pre-trial submission where there's an exchange between the parties of the evidence, the witnesses, and other materials prior to the trial. And then on the trial date, you show up, you have to bring all your evidence and your witnesses, and then if you're the plaintiff, you'll have your opening statement. Then the defendant will be able to make their statement, and then you'll start with your case. You'll provide witnesses, and after you examine your witnesses and present certain evidence, the other party will be able to cross-examine those witnesses. Then you'll keep presenting your witnesses. After you've presented all your evidence, you will rest your case, or you might make a certain motion after that. Then the other party will be able to present their case, present their witnesses and evidence. You will have the opportunity to cross-examine those witnesses, and after they're done, they might make a motion or you might make a motion, and if not, then there'll be closing statements. The defendant usually goes first, then the plaintiff will have the statement thereafter, and after the statements are made, either the matter is going to be submitted to a jury or the judge will make a decision in the matter. This was a very short overview of the litigation process, and if you have a certain matter that involves litigation and you want to consult an attorney, you can consult me, Richard A. Joel Jr. in Oradell, New Jersey, or you can consult another attorney that's familiar with the civil litigation process in the courts. Thank you and good day.